Akwabom State Chapter. My lord, parties are absent in courts.
Yes, parties absent, yes. Yes, appearance. Yes, any appearance?
Yes, my lord, there's appearance.
Okay.
Quickly, my lord.
Yes.
Emem Udo.
Yes.
Lord, I appear with my learned friend.
Right. Yes.
William.
Eh?
It's
Okay.
William Etugere.
Oh, William.
Etugere. My lord, Etugere is spelled ETOK.
Yes.
EREN.
Yes.
We appear for the first to third defendant.
Okay. Yes. Hmm? 80.
ETIMBUK.
Yes.
Dofia.
Yes, for the.
Seventh defendant.
Okay. Thank you. Yes.
Okay. My lord, the matter was adjourned to today for reports of settlement.
Yes.
As we are informed by the first defendants that they have settled with the claimants.
Yes.
And my lord, judging from the reports for the last 3 adjournments, the claimants have not been in court. Counsel who hasn't been in court. So, my lord, it appears they've lost interest in the matter since they have settled.
Yes.
Yeah. And so, my lord, in the circumstance, we pray in the court that the matter be struck out. We are most grateful.
Thank you. And Mr. Okon.
Yes, my lord.
Yes, Mr. Okon. Yes, the matter came up on the 18th of February. Was there any hearing notice served on the claimant's counsel? Hmm?
No, my lord.
And so. Yes, It appears that there's no hearing notice served on the claimant. Should we still?
Well, my lord, let's say in the interest of justice, we can take 1 hour. And if they're not here on the next day, we make the necessary application, sir.
Okay. Okay.
I mean, Lord, we also apply that hearing notice be said on the claimant and other access parties.
So, Mrs. Okondet,
Sure, my lord.
My lord, the 28th day of April is convenient to us. Thank you, my lord.
28th
Of April.
okay.
Yes, sir.
Udofia, is that okay?
Yes, my lord, it's convenient.
28th April. So since it appears that there's no hearing notice served on the claimant against today's date, I'm not inclined to striking out the matter. Rather, I reluctantly adjourn the matter to 28th of April 2026 for final report of settlement. Meanwhile, hearing notice shall be issued and served on the claimant.
As a
As a first basis.
if you agree with that.
Yes, thank you, Mr. Connors. Yes, Mr. Con.
NICN UY 49 2022 between Eneke Etemasupo and Prudential Guards Limited, Umana J. Umana. My lord, parties are absent in court.
Okay. Yes, appearance. Yes. 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 Mr. N. Indede. Yes.
My lord, I saw Ben Dede on the screen. But,
Eh?
I saw Barrister Ben Dede.
Okay.
But I've not seen him again.
What about have they filed their final addresses?
Yes, my lord.
All of them.
Yes, my lord.
Okay, let's stand it down.
Okay.
Let's stand it down. Call another case. Let's get done with the ones for mention or further mention.
Suit number NICN UY 30 2025 between Mr. Ubo Monde Udoyam and the Honorable Commissioner, Minister of Education in Akwa Ibom State, the Chairman, Akwa Ibom State Civil Service Commission, the Attorney General and Commissioner for Justice, Akwa Ibom State, the government of Akwa Ibom State. My lord, the defendants are absent in court.
Claimant present.
Yes, my lord, the claimant is present.
Yes, appearance.
The profound humility, my lord.
Yes.
My name is Mbet Okpawente.
Eh?
My home Mbet Okpawente.
Imbet.
My home appearance.
Yes, for.
The Clements. Hello.
Okay, thank you. Yes, Mr. Mbet, yes.
My Lord, it appears that the defendant cannot be presented by any counsel in court with their absence.
Yes.
I would like to inform the court that we were last year on the. We were last
Eh?
year on the. I would like to remind the court we were before my Lord on the 16th day of February 2025, as they became.
No, 2026. Is this year?
2026.
It's 10th of February this year.
February this year, my Lord.
Yes.
Well, we did inform the court that the defendants have been served and there's a proof of service in the court's file.
Yes. Yes.
Maybe for mention. But in the circumstance that I'm courageous enough to say that having been served and that not in court, the matter should be adjourned for definite hearing, my Lord.
They haven't filed any process.
I've not filed anything, my Lord. Maybe they're not interested. I've not filed anything, to the best of my knowledge.
Okay. Mr. Condet.
No, 29th of April.
Okay. Yes, Mr. Mbed, is that okay?
No, that is convenient to the council.
Mr. Con, 28 or 29?
Hello, 29.
Okay. So given the circumstance, case is adjourned to 29th of April 2026 for hearing. Hearing notice shall be issued and served on the defendants.
As God is.
My Lord, you're much obliged.
Thank you. Yes. Yes, Mr. Okon, yes.
Suit number NIC and UY 31, 2025, between Mr. Mbebe Silvanus Albert
In court,
and Honorable Justice Ekaite FF Obot, Akwa Ibom State Judiciary Service Commission, Jane Adi Anyang Esquire, Mrs. Grace Jonathan, Mr. Godwin Okon Charlie, Mr. Enefiok Essien. My Lord, the claimant is present in court, defendants are absent.
Yes.
Respectfully, my lord.
Yes.
My name is Fidel Albert.
Fidel
Albert,
Albes.
for the claimant. Grateful, my lord.
Thank you for the claimant. Yes.
believe me, Lord.
Huh? I can't hear you.
God,
EYO.
Okay, Ocon. Yes. Yes.
Not EO could
Yes.
appears for the defendants.
Okay.
Appear with my learned friend in phone Obong. Beyon.
On phone Obong.
Beyon.
Kenya. EKPEN.
EKP
N.
yes, my lord. YONG.
NJS.
You can log
You
appeal
are
for the defendants. We
okay.
appeal for the defendant. All the
Thank
defendants.
you. Yes. Yes.
Yes, my lord. The matter was adjourned for further mention, I believe. Unfortunately, my lord, I wasn't in court at the last adjourned date, but I was
Yes.
told by my colleague who held my brief that
Yes.
matter was adjourned for further. We've been awaiting service of processes from the defendants. We've not been
Yes.
served with any as of yet. So I do not know what they intend to do, my lord. Otherwise, we would have just asked my lord to respectfully adjourn the matter for hearing. They're long out of time.
Okay.
Uh,
Okay. Let's hear from the counsel for the. I think there is a process that was filed. Yes.
We filed the motion. We filed the motion on the 23rd of this month, 23rd of March, 2026, for the striking out of this suit. And same was served on the defendant on the address they gave us within jurisdiction. Because they gave us an address within jurisdiction for service. Probably he has not been served by the office, which he gave us, but we have served that office.
So you filed a motion which was served, Mr.
Yes, my lord. The motion was filed on the 23rd of March, 2026.
Okay.
Yes, sir. So they may want to confirm from the office within jurisdiction. Probably take a date to respond. To respond if they intend to.
Yes, Mr.
my
Fidel.
lord, I do believe that it is the party who says he has served that should show my lord the proof of service. I am sure if my learned friend says, because I am in constant touch with our address within jurisdiction, if my learned friend has served, he must have an acknowledgement of service. Because I do not want us to mislead the court today. So
The motion was filed, Mr. Mfon. It was filed on the 22nd of
23rd, my lord, 23rd. That was Monday.
on Monday.
23rd of this.
And yes, Mr. Okon,
Yes, my lord.
was that motion served? Motion filed by the defendants on the 23rd. Eh?
I've seen proof of service here.
Okay, served on who?
Serve on the Claimants Council,
Okay.
Albert, care of Anatia, Dustin, Eswell.
Okay. Yes, Mr. Fidel, is that your address for service within jurisdiction?
my lord, that is the address for service within jurisdiction.
Mhm.
What I did ask if the registrar may show, because I am absolutely what the registrar read was an address within jurisdiction, not an acknowledgement of service. If you serve someone, someone would have accepted it and signed for it. So if my lord would be pleased, I would want to confirm who signed for to be sure, because I have my address for service within jurisdiction of my processes, and anybody can read that to the court. But it's important.
Okay. Yes, Mr. Okon, who signed the process?
Esther Edem. Esther Edem.
Oh,
Okay.
very well, my lord. We'll confirm that. We'll confirm that service because we have not been told.
So, Mr. Fedel, we adjourn for hearing of the motion.
But my lord, incidentally, my lord's rules has a very unique. I do not know if the defendants have taken cognizance of the rules of this court, which is rather peculiar. My lord, my lord's rules provide is for, so that there are no delays, is for objections to be raised in your defense. That is what my lord's rules provide. And so, because we ought to take a date for trial, they have not said they have filed any defense. They have just said
the defendant can't raise any objection, in a way of preliminary objection before before the trial is commenced. No objection can be, even if it's an objection that has to do with the issue of jurisdiction.
I'm sorry, my lord.
What I'm saying is that, can the defendant raise, objection to the?
My lord, what my lord's rules provide is that you can raise it, but it must be in your defense.
Under which?
My lord, unfortunately, my rules is not here, but it's a well-known provision of my lord's rules. I mean, if my lord can give me a stand down a few minutes, I'll get the rules and read it to my lord.
Stand down.
Respectfully, even the industrial court's practice directions allows us to raise this objection to the competence of this suit. To the competence of the suit.
Mr. Your objection is on what?
Non-compliance with the provision of the practice direction.
Okay.
My lord, as we can see, so that is a procedural objection. It's not a substantive objection of the jurisdiction of this court.
Yes.
Yes. So all this is just done to waste my lord's time.
Please. Yeah, somebody has filed an objection, Mr. Fidel. You haven't even seen, the process.
My lord, he has stated what he has filed. He has said
yes,
that it is not even non-compliance with rules, but practice direction. That's what he said.
In respect, my lord, if counsel intends to,
yes, but because in the practice direction issue, they are saying that non-compliance, will amount to striking out of the matter. It didn't say it's just an irregularity.
Okay, my lord.
This is an irregularity. If I can remember that issue of marking, Mr. Enforcing the issue of marking of exhibits and referring to the exhibit in somebody's pleadings. Is that the issue you are raising?
Yes, my lord.
Eh?
Yes, my lord.
So if that's the case, Mr. Fidel, that's a fundamental issue.
Well, my lord,
That's
my
why I'm
lord,
saying that let's just adjourn to enable you react, isn't it?
yes,
Yes, let's just adjourn to enable you react. To enable you, look at the process.
yes, my lord.
If you want to react, then if you want to raise any other thing, you can, isn't it? So it means we should adjourn for further mention of what?
Oh,
Mr. Amford, you haven't yet filed any defense, ba?
You know, this is a fundamental issue. If this matter at the end of the day is resolved in our favor, then we don't file a defense.
Okay. So what do you do now? Should we adjourn for further mention or for hearing of the?
my lord, this is the issue. This is the reason why I
Yes.
raised this issue, because my lord has heard what my learned friend has said, that
Yes.
if this doesn't go in their favor according to them, they will file a defense. My lord, this
Yes.
is why these issues, the NIC rules is sui generis to the NIC and has made specific stipulations for how objections should be raised in his court. So my lord, the point is, why do what the defendant intends to break this case into bite sizes and to come in piecemeal so that we can be here forever. The point we are trying to make is that if they intend to raise the issue, how can a party who is complaining of non-compliance in itself be in non-compliance? Because the rule says raise your objections in your defense. You have not done so. So because what would happen is...
But Mr. Fedin, is it any objection that should be raised in the defense? Is it any objection that should be raised in somebody's defense?
In fact, even the most serious one that is jurisdictional, the most serious one, not even procedural, jurisdictional. It says, and the reason is because the rule intends that the the objection be taken at the end of the proceeding, so that we don't waste time.
No, so, it's not in all cases, though. It's not in all cases. There are some
as the court pleases.
Yes, that there are
as
some
a So, my lord, may we respectfully suggest the 28th,
yes,
to come back on the 28th of April. My lord, for further for further mention, by then we would have filed our processes or hearing. Yes, my lord. Hearing of the application. Of the application, my lord.
Okay.
Not convenient for me.
Not 28th of April is not convenient for me.
So my lord, I have a case in Uyo on the 27th. So I just wanted to stay and enter this one on the 28th. I am sure my learned friend came to the court with other counsel. He's not the only person in their chambers. If it's not convenient for him, he appeared with juniors. Anybody can come and argue. He has already filed the papers.
Mr. Felix, are you the one to tell somebody who is to handle his case, Mr. Fidel, please? In all fairness to if somebody is doing his case, as a counsel from the opposing side, are you the one to tell him that no, you don't need to be the one to come and handle the matter? You can send another person, Mr. Fidel, please.
My lord, it's not me. It's the Supreme Court.
It's a matter of date, please. If somebody says the date is not convenient to him, just allow him to take any convenient date.
My lord, the Supreme Court has said.
Mr. Onfon. Which date is convenient to you, please?
29th is convenient.
29th. Okay, Mr.
My lord, it's not convenient for me, with the greatest respect.
Why wouldn't you also send another person to hold your brief?
So my lord, this is the issue, my lord. My lord, this is the issue. I am not saying.
Why don't you send, since you have somebody in Uyo that will handle your, why don't you send him to come and do your case? You see, about Mr. we have to be fair to.
My lord, if I can respond.
He's saying 28 is not okay, and you are saying that no, he should say somebody. There are so many counsel, and you don't want to send another person to come and hold their brief.
My lord, if my lord has asked a question, maybe I can.
Maybe it's not okay for you.
My lord, I can respond.
It's not okay for you, isn't it, Mr. Okon? Which date is convenient, please, to follow up us? So that we just adjourn. Simple something, but we are trying to create, yes, Mr. Okon, convenient to all of us, please.
Okay.
My lord, 29th is convenient for the court, 28th
Mr.
is
Fedel
not
said it's
convenient
not
for us.
convenient to him. Why wouldn't you give us another from the, from the diary, a convenient date, from the diary?
My lord, 4th of May.
4th of May.
My lord, I wanted to suggest if we could take that 27th in the afternoon. I would have been done with the other case.
Is
27th.
27th okay for Mr. 27 is on which date, and Mr. Con?
The Monday, my lord.
Mr. Onfon, is 27th okay?
In the afternoon, my lord.
In the
That 27th, we are in Oron. Not even in Yobe,
the afternoon.
we are in Oron. We have a matter in Oron.
He said in the afternoon.
We don't know what time the afternoon starts. My lord,
Since we become
afternoon,
Uyo
maybe we can.
7th, eh? Mr. Onfon,
If we finish on time,
Fine.
Mr. Okon on
maybe
27th.
1 o'clock.
Eh? What time?
1 o'clock in the afternoon.
4 o'clock.
1 p.m. 1, not 4.
Okay.
1.
Mr. Okon, how many cases do you have on the 27th? Mr. Okon.
Hello, we have 9 cases on the 27th.
Oh.
And they have hearing, cross-examination, and 1 further mention.
Okay, let's just manage it. 2-7 by 1 o'clock. Mr. Fele, is that okay?
My lord, we're very grateful for the accommodation. Thank you very much.
Mr. Onfon, is that okay?
Yes, sir.
Mr. Onfon, is that okay?
Yes, my lord. Yes, my lord.
Okay. So, Mr. Fed is going to be for hearing of the motion or for what? Or for just further mention?
But my lord, since they have a motion, it has to be, I would suggest it's a hearing of their motion, my lord.
Okay.
We're grateful, my lord.
So, given the circumstance, case is adjourned to the 27th of April 2026 at 1 p.m. for hearing of the defendant's application.
As a court please. My lord, we're very grateful.
Thank you.
Wish you the best of proceedings ahead, my lord.
Thank you.
Yes.
Okay. Mr. Okon, yes?
Suit number NICN UY10 2024 between Emmanuel Udama Ode and Wheels Pharmacy Limited in Mowo, Udobia. My lord,
Yes.
parties are in court.
Parties are
absent in court, my lord.
yes. Parents.
With humility to this honorable court,
Yes.
my lord, my name is Godwin Edogo, and I appear with my learned friend, Iridion Udom. Our humble appearance is for the claimant applicants.
Edidian.
Claimant applicant, my lord.
Edidian.
Okay, Iridion Udom, my lord.
Okay. Udo.
Yes, my lord. UDOH.
Okay, okay. For the
For the claimant
claim.
applicant. Claimant applicant. We apologize
Yes.
for his absence.
It's okay, thank you. Yes. Mr. Charles. Yes.
With profound, may my Lord
Yes.
be pleased to hear if your Charles.
Yes. Yes.
But my appearance is for the defendant.
Yes. Yes. Yes, Mr. Godwin, yes.
My lord, we have a motion on notice which was filed and served on the defendant's respondent lawyer, my lord.
Motion for amendment.
Yes, my lord.
Yes, Mr. Charles, is there any objection?
Yes, my Lord. But that's the position.
Is there any
They
objection?
didn't know.
No, my Lord, will not be opposed.
Okay.
My lord, with your leave, may I proceed to move the application?
Okay, just a minute, please. Yes, Mr. Godwin.
Yes, my lord. My lord, the motion is dated 10th February 2026, but filed on the 16th of February 2026.
Yes.
It is brought pursuant to Order 26, Rules 1, 3, 4, 5, and 8.
Yes.
Order 26, Rules 1, 3, 4, 5, and 8 of the National Industrial Court of Nigeria, Civil Procedure Rules 2017, and under the inherent jurisdiction of this court. My lord, the motion prays for leave of this court to bring this application for amendment of the complaint, affidavit of variation, statement of fact containing the cause of action, witness deposition on oath, list of witnesses, and list of documents to be relied upon, and other accompanying documents of the claimant in this case. My lord, and also an order of court amending the complaint, affidavit of variation, statement of facts, establishing the cause of action, witness position on oath, list of witness, and list of documents to be relied upon, and other accompanying documents of the claimant in this case to correct an error or defect in the name of the first defendant. My lord, in accordance with the rules of ESCOT, this motion is supported by an affidavit of 9 paragraphs, deposed to by the claimant applicant himself. Exhibited there are 3 exhibits. My lord, the exhibits are marked exhibit A, B, and C. My lord, exhibit C is the proposed amendment. My lord, the application is accompanied by a written address, which we respectfully adopt as a legal argument in urging this honorable court most respectfully to grant the application. My lord, the application is simply, we are seeking simply to remove the extra L in the name of the first defendant. We, in error, stated it as we will with double L, but we are asking the court to allow us amend it by removing the extra L so that it can be we will with one L. Well, that's the purpose of the amendment.
Okay. Thank you. Thank you, Mr. Charles. No objection, ba?
Yes, my lord. As I earlier indicated interest, we are not opposing, but however, my lord, will apply that my learned friend compensate us because we had earlier filed a motion to strike out this suit. But based on the rules, that when there are two competing applications, one seeking to end the matter and one seeking to revive the suit, we had to subpedal on our own for theirs to go on. We had filed application, so we just ask a learned friend to compensate us. If he can give us a token of 50,000, we appreciate. Thank you so much, my lord.
So Mr. Godwin, how much are you considering to?
Respectfully, my lord, even though they did not file any response to our processes, they only
No, but
filed
they're to strike out the name of the second defendant.
yes, and that was the only thing they filed. Assuming they had filed a statement of defense, they didn't file anything. The only thing they filed was the motion and memorandum of conditional appearance. However, my lord, amendment is a constitutional right of the claimant applicants. This is the first time we are amending, and my lord, we are simply removing one L.
It's a constitutional right.
My lord,
How is the amendment a constitutional right? The amendment, how is it a constitutional right?
We can amend twice before judgment.
No, I'm saying that how is the amendment a constitutional right? You are saying it's a constitutional right?
My lord, it's part of right to fair hearing if we look at it in the broad perspective.
The amendment?
Yes, ma'am.
How does it affect the issue of fair hearing? Something that's the court can decide to to refuse the amendment, isn't it?
Yes, my lord.
I don't think it's a constitutional right. It's just any other right.
Okay, my lord, we say it's legal right, not constitutional.
Maybe you can say it's a legal right.
Thank you.
It's a right provided by the rules, but I don't think it's provided for by the Constitution.
Well, what they file is only about 6 pages. My lord, we can consider 3,000. This is what they file, 3 documents.
The fuel now is how much, Mr. Godwin? Fuel.
It's the first time we are amending. That's why we are asking my lord, it is just a simple error of counsel. So we are asking the court to temper justice with this. You can consider 3,000.
And Mr. Charles,
Yes, my lord.
aside from your
it's not a 3-page document. We found 11 page document.
aside from your motion to strike out the name of the second defendant, you haven't filed any process.
No, my lord. On the ground that when we discovered that irregularity, we knew that if this matter succeeds at the end of the day, we will still need to refile again. That was how we filed this motion, and they did not react to our motion. Rather, they came with the motion that had just been moved, and we did not want to delay the matter further. That's why we did not want to react
to 3,000.
No, my lord, 3,000 is too meager. We had filed a process of 11 pages, and we even take a look, say we understand the current state of economy now. So, my lord, offering a lawyer 3,000 is not what my learned friend should offer.
So, okay. So Clement's application for amendment of his complaint and other processes dated 10th February 2026, but filed on the 16th of February 2026 is granted as spread. 5,000 naira cost is awarded in favor of the defendant against the claimant. Yes, Mr. Godwin. Yes.
As a court pleases.
So Mr. Charles, are you applying to withdraw your application?
Yes, my lord.
Okay. Mr. Godwin, no objection.
No objection.
Mr. Charles, your application is dated and filed when?
Lord, on the 31st day of October,
Sorry.
31.
Sorry, my lord. I didn't hear which application.
His application to strike out the second defendant's name was filed when?
Okay.
My lord, 31st day of October, 2025.
And dated when?
My lord, it was filed on the 21st. It is dated 30th. I'm sorry, my
Okay.
lord. Dated 30th October and filed on the 31st
Okay.
of October.
So defendant's application dated 30th October 2025, but filed on the 31st October 2025, having been withdrawn, is hereby struck out.
As a court pleases.
Yes, Mr. Godwin, we adjourn for what?
My lord, we will file the amended document and save on them.
Okay.
So it should be for me.
Okay.
Yes. My lord, respectfully, we suggest to return on the 5th day of May for mention.
Okay. Mr. Charles, is that okay?
Yes, my lord, it's convenient.
Okay. Three Meva.
No, my lord. 5-5.
Okay, 5-5.
5-5. May, yes, my lord.
Okay. So case is adjourned to the 5th of May 2026 for mention. Yes. Hello, yes, Mr. Okon. Sorry, gentlemen. I'm so sorry. Yes, Mr. Okon.
Yes, my lord. Suit number NICN UY 48 2024 between Mrs. Linda Ayomba and Heritage Bank Limited and National Deposit Insurance Corporation. My lord, parties are absent in court.
Yes. Yes.
Very
MMS.
respectfully, my lord. Ms.
Yes.
Udo. Lord,
Yes.
I appeal with my learned friend, William Etugere.
William A.
Etugere. My lord, Etugere is spelled E-T-O-K.
E.T.
O-K.
Uh-huh.
E-R-E-N.
Yes.
My lord, we appear for the judgment screen.
Yes. Yes.
My lord,
Ye-
we not have an interest in pursuing this matter for because it's
Okay.
currently on appeal.
On appeal?
Yes, sir.
Okay.
Lord, we shall be asking the court for a striking out of this suit.
Okay. Okay. The second garnish was discharged, isn't it?
Yes, sir.
Just So, in view of the application of the Land Council for the judgment creditor to strike out this matter, this suit is hereby struck out, and the first garnishee is accordingly discharged.
Thank you, my lord.
Thank you. Yes, yes.
Suit number NIN-UY04 2024 between Mrs. Patience Daniel Afaride and Cashright Microfinance Bank Limited.
President,
Please your name and your designation.
Akpan Robson. Tenant control.
Internal control.
Yes.
My lord, parties are present in court. Defendant is represented by Akpan Robson, internal control officer.
Yes.
My Lord, we respect. My name is Silvanus Obod.
Silvanus.
I know Silvanus A initial Obod Romeo.
Yes. You are
I
alone.
appear with my name.
Okay. Okay, you can go
My
on.
Lord, yes, sir. My colleagues are appearing with me, Emmanuel E. Bass.
Emmanuel.
And
And who again?
Aniekan Akban. Aniekan Akban.
Yes.
Thank you, my Lord, for the claim.
Thank you. Yes.
Thank you.
Yes.
With humility to this court.
Yes.
My name is Godwin Edu. And my Lord, I appear with my learned friends, Gideon Woodall, Esquire, and Joseph Ele Esquire, for the defendants.
Vivian.
Gideon Woodall.
Okay, Gideon.
And
Okay.
Joseph.
And Joseph.
Ele. Joseph Ele. Ele is capital ELEH.
Okay.
For the defendant.
Okay. Yes, Mr. Obot.
My Lord, the matter is for cross-examination of DW1.
Yes.
If it's in
And
court,
okay. You are ready?
Very well, sir. My Lord, we are applying for the exhibit, then proceedings.
Yes. Yes. Mr. Okon. Yes. Yes.
Is it Robinson or Robert? Robson. Second Robson. Please tell this court when you joined the service of defendant.
So, Mr. Okon,
Yes, my lord.
he's reminded that he's on oath, ba?
Yes, my lord.
Mm-hmm. Yes.
My lord, I'm asking the witness to tell the court when he joined the service of the defendant as his.
Yes. Yes.
My lord, I joined November 2020.
In November
2020.
Yes.
Thank
Yes.
you. You were not the claimant's immediate supervisor, or were you? You were not the claimant's immediate supervisor when the claimant was in the service of the defendant.
My lord, I wasn't.
I was not the claimant's immediate supervisor. When the claimant was in.
In the service of the defendant.
Okay. Yes.
You did not also work in the marketing department where the claimant worked when she was in service of the defendant. You did not work in the marketing department of the defendant when the claimant was working there, or did you?
My lord, I did not.
I did not work in the marketing department of the defendant when the claimant was working with the defendant. Yes.
Thank you. Witness, please tell this court who was the claimant's immediate supervisor when the claimant was working in the. Who was her immediate supervisor when she was working there?
My lord, I can't remember.
I cannot remember who was the claimant's immediate supervisor. Yes, supervisor. Yes.
My lord, I applied to the court for exhibit PDA1, I suppose.
Yes.
That is later of appointment of the claimant as a staff when she was working there, and the staff handbook. My lord, I can't recall what exhibit was that. Staff handbook of the defendant. Thank you, exhibit. My lord, I'm showing exhibit PDA1. This is a good, like one. Sorry. My lord, exhibit PDA1 and exhibit CRM2 to the witness.
Okay.
Witness, can you take a look at those documents? Those are the two documents that constitute claimant terms and conditions of service. Exhibit PDA1 and exhibit CRM2 where and are the two documents that constitute the terms and conditions.
CRM2.
CRM2.
My lord, CRM2.
Yes, and
RM2.
they are the same document.
No, they are two documents.
No, but are they the same? Are they the same thing?
No, my lord.
Oh, they are
They
different.
are different documents. Yes, my lord. Exhibit PDA1 is later of appointment
Okay.
of the claimant.
Okay.
While exhibit CRM2
The handbook.
is the staff hand. Yes, my lord.
Yes. Yes.
These two documents constitute the only terms and conditions of service for the claimant when she was working with the defendant. That is correct. What is with you?
Hmm?
We're waiting for you.
My lord, it is not.
Okay, the employment letter and the defendant's handbook, you are saying that they don't constitute the terms and conditions of the claimant's employment or what?
Yeah,
Mr. Howard, I think that's the question you asked him, huh?
Yes, my lord.
Yes. Did you actually understand the question, Mr. Akpan?
But he said it's
Mr.
not the only document.
Okay.
They are
Okay.
documents.
Okay. Exhibit
PDA1 and CRM2
PDM1 and CRM2 are not
the only terms and conditions of service of the claimant.
terms and conditions of service of the claimant. Yes.
Can you mention to this court other documents of terms and conditions of the employment of the claimant when she was working there? Go ahead and tell.
My lord, I don't have them here with me.
Mention, I didn't use them. I said mention other documents of terms and conditions of service of the claimant when she was working with the defendant.
He said he doesn't have them. Or what? He said he doesn't have them.
Yes, my lord.
Okay. Yes.
Mr. Robert, Mr. Pan Robert. Robson. Let me write it here. Robson. You still maintain that since you joined the service of the claimant, you work only
in the internal control unit, or you are the internal control officer of the defendant?
I worked as internal control officer. My lord.
Does it mean you've not worked in marketing department before?
My lord, by virtue of my position,
Do you work in the marketing department of the defendant?
my lord, please can I respond? It is not a
So
yes or no question.
you say whether you worked in the marketing department of the defendant, isn't it?
Yes, my lord.
You worked? Have you ever worked in the marketing department of the defendant?
My lord, with due respect, it is not a yes or no question.
Have you worked there? Answer my question. Don't waste our time. We have a long way to go.
My lord, please can I respond?
You enter this witness box. Mr. Robson, please.
You say what?
Have you worked in the marketing department of the defendant before? Answer it, then you can explain.
My lord, please can I respond?
That's what we are expected to do now, to say yes or no, whether you have worked in the marketing department of the defendant. It's a yes or no answer, isn't it?
My lord,
Yes.
I have an explanation. So it is not a yes or no question.
What is the explanation?
But thank you, my lord. The explanation is this: by virtue of my position as internal control officer, I inspect and oversee the activities of all other departments of the bank.
Yes, but he's saying that to work and inspect is something else, but to work in a particular department is another. What he's saying is that maybe you can say as an internal something. You say internal what? Internal
Control officer, my lord.
Internal
Control officer.
control of yes. What is now is now being specific that have you worked in the marketing department of the defense? That's not the question.
No, my lord.
No. But as an internal control officer, you supervise them.
Yes, I inspect the activities, yes, of all departments, including the marketing department.
Good. It's to inspect. You can
My
inspect
lord?
them. You can inspect them.
Yes, I inspect the activities and everything they do.
Yes.
And present report to management.
I've never worked in the internal, sorry, in the marketing department of the defendant, but I can inspect all the departments. Yes.
Thank you, my lord.
Yes.
Mr. Akpan Robson, you are familiar as an internal officer, auditing or control officer. You are familiar with marketing and procedure of granting loans to the customers of the defendants. Are you or you are not?
I am.
Well,
my lord.
He said what?
I am familiar, my lord.
You're familiar with what?
Yes, my lord, the question is if he's familiar with the marketing procedure of granting loans to customers of the defendants.
I'm familiar with the marketing procedure of granting loan to customers.
Granting loans to customers of the defendants.
Yes, he said yes. He's familiar.
Yes.
Yes.
My lord, I applied for exhibit. That should be exhibit. The letter of
letter of what?
letter of resignation. My lord, is exhibit CRM3.
Yes, CRM3, one dated
Exhibit
22nd March 2021.
22nd March 2022. Thank you, my lord. Thank you. I show it. Please tell the court what date is stamped that letter was received by the defendant, and what date it is stamped date as the date they received that letter. Exhibit CRM3. What date did the defendant receive that letter?
Is this okay? Yes.
My lord, 21st of March 2021.
21st of March 2021.
Okay, exhibit CRM3 was received on 20.
My lord, 21st.
Of March
2021.
And it was received on 21st of March 2021. Received by the defendant.
Yes, my lord.
But it's dated 22nd of March.
My lord, we are asking the date they received it, sir.
Eh?
It's stamped there, sir. The date they receive it.
Yes, 21st of March 2021, isn't it?
Thank you, sir.
But it's dated 22nd, isn't it?
My lord will come to that. We are coming.
Okay. Thank you. Yes.
Mr. Robson, that is the letter you said in paragraph 7 of your evidence that it was forged. That is a letter in paragraph 7 of your evidence. You said that it was forged.
Official evidence.
This man's evidence.
We have to evidence. We have to evidence. There's a fake one. There's a little wait. We have statement of defense, and we like the statement and defense department to. This is not the letter.
Okay, which other? In paragraph 7 of your evidence, that means that your pleading. Is that the letter you said was forged?
My lord, this is not the letter.
No. My lord, you said that is not the letter. Please return it to. Now, in your exhibit CRM4, exhibit CRM4, dated 12 May 2022. In your exhibit CRM4, please take a look at it. Dated 12 May 2022. And I think CRM5 as well. The sum of 1,897,191.85 that you mentioned in that letter were not given to the claimant as a loan. Was it given to the claimant in person as a loan or as a grant or a salary?
My lord, please, I want the question to be rephrased.
The amount of money, 1,897,191.85 were given to various customers of the defendant. Is that correct?
That's correct.
Thank you.
Thank you. According to exhibit CRM
4. Let me see, CRM 5. My lord, and CRM 5.
Okay, and 5.
Yes, CRM 5.
4 and 5.
4 and 5. Yes, ma'am. Thank you. Yes.
The sum
The
of
sum of
1 million.
yes, I have CRM 4 and 5.
And then 7, eh?
My lord, exhibits CRM 4 and 5.
Yes.
The sum of
1,897,191,85 kobo.
yes, my lord.
What was given to the customers or what?
Were given to the customers of the defendants, not the claimant in person.
Okay. Yes.
Thank you.
Yes.
That is, my lord, thank you. I'm showing exhibit CRN4 again to the claimant, to Mr. Robson. Yes. Mr. Robson, in that exhibit CRN4, the list of the names of the beneficiaries of the loans are attached to that exhibit 4. Take a look. The names of the beneficiaries of the loans were all attached to the letter. Is that correct?
They are attached, my lord.
Okay. That from exhibit 4, the list of the
loan beneficiaries
are attached.
Yes.
Oh, it's attached.
Sorry, sir.
It's attached, ba?
Yes, my lord. Thank you. My lord, can we make progress?
Yes.
Thank you. No, sir. Hold that. Hold it. Please take a look at the list. Go to the list. Tell the court the total number of the names of the beneficiaries on that list. The total number, serial number, 1 to how many constitute were the beneficiaries of that loan of 1,897,191,85. How many beneficiaries?
My lord, 51.
51 beneficiaries obtained the loans of the total sum of 1,897,191,851. Excuse me, too confusing.
Yes.
Thank you, my lord. Mr. Robson, please take a look at the list of those loan beneficiaries. The last column on the list, they are in column. The last column there shows who the loan officer were. The last column on the attached list of the loan beneficiaries show who was the loan officer of the defendant. Is that correct?
That's correct, my lord.
It shows what?
My lord, the last column on the list of the loan beneficiaries show who was the loan officer.
Okay.
The loan officer of the staff of the defendant.
That is the last column of exhibit CRM for what?
The list attached to exhibit CRM4, which I think my lord treated it as one.
The last column. The last column
The
in the
last
list.
column on, yes, attached to exhibit CRN4.
On the list attached
to exhibit CRN4.
to CRM 4
Yes, my lord.
shows that
Shows the name of the staff, the loan officer. Show the name of the
Shows
staff
the-
officer or the loan officer of
shows the
defendant.
name of the loan officer.
Loan officer who was the staff of the defendant.
Okay.
The loan officer who was the staff of the defendant, sir.
Yes.
Thank you, my lord. Mr. Robson, please, let's still look at that document and explain a few things to us. Please look at that list. Oh, my lord was expecting an answer. The answer.
What I recorded was that the last column on the list attached to exhibit CRM 4 shows the name of the loan officer.
Thank you.
Yes, you can proceed, yes.
Thank you, sir. Mr. Robson, take a look at the serial number. The serial number 1 to 8 on that list, there is no mention of the name of the loan officer. Look at
Serial
that
number.
Serial number 1 to 28 of the list attached to exhibit CRN4. My lord, we are dealing with exhibit CRN4.
Yes, you said that the list contains 51 names.
That 51 names, yes, sir, of loan beneficiaries.
Yes, and beneficiaries, yes. And you are now, yes, the question is
that from serial number 1 to 28, it does not mention the name of who was the loan officer of the defendant. Just for him to clarify if it is so.
Yes.
My lord, it does not.
Okay.
Serial number 1 to 27 and not 28. Serial number 1 to 27.
Okay.
Okay.
There's no mention of the loan officer from serial number 1 to 27. That's on the list.
Yes, my lord.
Yes. Yes.
Mr. Robson, please confirm to this court that it is only from serial number 28 to 51 that the claimant's name is mentioned. Is that correct?
Yes, my lord.
Okay, but the claimant's name
is mentioned as the loan officer from serial number 28.
As the loan officer from serial number 28 to
51.
51. Yes. Yes.
Thank you. My lord, I'm grateful.
Thank you.
Mr. Robson, you told the court that you are familiar with the loan procedure, granting of loan, marketing and granting of loan procedures in the defendant. Please tell this court, all the beneficiaries of the loans, various loans granted by the defendant, fill form and apply for it.
Please, my lord, the question should be rephrased.
All the beneficiaries, those who benefited or whom the defendant granted loan, applied, filled forms and submitted the necessary requirement, made with the necessary requirements of the defendant before they were granted the loan. That is correct. They don't apply for the loan.
My lord, I still don't get his question clearly.
Okay, but you can rephrase it,
Alright.
Mr.
Is a defendant a bank? Defendant is the bank that grants loan to beneficiaries. Is that correct?
Yes, Mr. Witness is asking you whether the defendant is a bank that grants loan to its customers. Is that right?
Yes, my lord.
Yes.
Those customers applied for various sums of loan and will be
Hello, Mr. Kon. Good afternoon. Hello, can you hear me? Mr. Kon. Can you hear me? Hello, can you hear me? I hope it's not data issue. Whose data are you using? Eh? Oh, okay. Whose data are you using? Eh? Okay, from your phone. Do you use this number? This what's the 630 something, 36 something? Eh? 81. Is it 81? No, the number is it 81 or? Okay, trade. Okay. Let me send the data to you. Mhm.
number you dialed is switched off.
Hello? Yes.
Hello, thank you for the benevolence. Of the possibility of the network. We actually understand them.
Thank you. Thank you.
Let's expect progress we soon round. Yes.
Okay.
Mr. Robson, in your banks, do they require for guarantor before a loan is granted to a beneficiary?
Yes, my lord.
Okay, that a customer requests a guarantor before he's given a loan?
The defendant always requires or requests for a guarantor before a customer is granted a facility or a loan.
Okay. Yes.
So it is correct that all the 51 names of the loan beneficiaries in the list attached to Exhibit C, R, and 4 provided guarantors to the defendant before the facility was granted to them.
Yes.
My lord, it is possible.
Eh? It is possible.
Yes, my lord.
Yes.
Thank you.
That all the 51 beneficiaries of the loan granted, provided, yes, they provided grantors, yes.
Thank you. Now, Mr. Robson, as internal controller, it is correct that all these 51 loan beneficiaries have an account with the defendant. All these 51 names of loan beneficiaries have an account with the defendant. They open an account and maintain an account with the defendant. Is that correct?
That is one of the conditions, my lord, for granting loans.
Okay, so you don't need to open an account with the defendant before you are granted loan, isn't it?
No, my lord, it is one of the conditions before loans have been granted. To open
That you-
accounts.
So it means all the beneficiaries have accounts with you, is that so?
Yes, my lord.
Yes.
Yes, we will have to be present.
Yes.
Now, in banking reconciliation, it is the statement of account of the customer that you use to reconcile whether it is in debit or in credit. That is correct. As internal auditor, in reconciling accounts of a customer, it is the statement of that account that you will look at to reconcile whether the account of that customer is in credit or is in debit. Confirm to this call.
My lord, it's not only the banks.
You see, the statement of account is one of the documents you will require in reconciling whether the account of that customer is in credit or is in debit.
My lord, it is one of the documents and not the only document required.
So statement of account is one of the documents to look at reconciling whether an account is in debit or credit, isn't it?
Yes, my lord, one of the documents.
Yes, one of the documents, yes.
Please, do you have the list of the guarantors of all these alleged 51 loan defaulters? Do you have the list of their guarantors before this court?
Yes.
My lord, I don't have the list with me.
I do not have the list of the guarantors of the beneficiaries of the loan. Yes.
Mr. Robson, please tell this court, do you have the bank statement?
Sorry, my lord, the last answer is not list of beneficiary. The question was list of guarantors in court, which he said he does not have. List of
He said
guarantors.
he does not have the list of the guarantors to the beneficiary, isn't it?
Yes, my lord, not beneficiaries.
No, I didn't. No, I said guarantors to the beneficiaries.
He said, to proceed and leave first. Yes, my lord, we are on the same page with the court. Thank you, my lord.
Yes.
Please, Mr. Robson, do you have the statement of account of all the 51 alleged loan beneficiaries before this court?
My lord, I don't have them here with me.
The list of what?
The statement of account, of all the 51 alleged loan beneficiaries.
Okay.
Or loan default. Yes, sir.
So I don't have the statements of account of the 51 beneficiaries, isn't it?
Of all the 51 alleged loan beneficiaries to defaulters.
Yes.
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 Now, it is correct that the claimant was not a guarantor to any of those loan defaulters or loan beneficiaries. She was not a guarantor.
Yes. Yes.
I can't confirm that, my lord.
Eh? You can't say. Okay, you cannot confirm. I cannot confirm whether the claimant was not a guarantor to any of the beneficiaries of the loan. Yes.
Thank you, my God. Mr. Robson, yes. Please tell this court, it is the sum total of the alleged loans of these 51 loan beneficiaries that you are counterclaiming from the claimant. It is the sum total of the alleged loans given to these 51 beneficiaries that you are asking the defendant, the claimant, to pay to you.
That is the 1,807,000 naira.
Yes, my lord.
Okay, yes. Yes.
Yes, my lord.
Yes, it is the sum total of the loan collected by the 51 beneficiaries.
51 beneficiaries, yes, ma'am. Yes, my lord.
That we are asking the claimant to pay. Yes.
My lord, I applied for exhibit POA 6
Do you have any POA or PDM?
Oh, my lord, oh, sorry, PDA 6. Thank you. Yes, sir.
That's letter dated 29/11/2022.
Yes, my lord.
Very well, my lord. My lord is
Yes.
November 29, 2022.
Yes.
Much of that, sir. Thank you. Mr. Robson, kindly take a look at that exhibit. Tell the court, is that the status report required by Bonfadama? Exhibit PDA was written by the defendant. Confirmed. Was it written by the defendant, Bonfadama?
Exhibit PDA what?
PDA 6, number 6.
Okay, whether it was written by the defendant.
I'm asking if that is the status report required by Ibo Fadama from the defendant.
My lord, I can't get his questions clearly as it does not relate with what I'm holding here. So you may want to rephrase his question.
Yes, Mr. Oko.
You are highly educated. Look at that document. That's why it's.
My lord, I'm having outstanding balance, but the question is asking me is not relating to what I'm holding.
I'm asking you, look at that document. Is it this what is called status report that is required by Ibo Fadama?
My lord, this is an outstanding balance of 1,703,401.
Mr. Abbott.
Yes, my lord.
That exhibit was issued by who?
By the defendant.
Okay.
Yes, sir.
So your question is, and your question is whether
it is what is called status report.
Okay, yes, Mr. Akpan, Mr. Witness.
My lord, the subject here is outstanding balance
report. Yes or no? Then you can explain it.
Yes, Mr.
No, it is an outstanding balance of 1,703,401 kobo, being past due obligation of patient Daniel Fadi, the loan customers in Cash Microfinance Bank. That's the subject of the letter, my lord.
Thank you.
Okay, so exhibit 6 is what do you call it? Start and balance what? You call it?
Outstanding balance of 1,703,401 naira 23 kobo.
So it is not the status report.
Being past due obligation.
So exhibit PDA 6 is not a status report? Yes, Mr. Witness.
Yes, my lord.
Is it a status? Okay. It's not a status report, isn't it? But it is. You call it. An outstanding
balance of 1,703,000.
Yes.
101.23 kobo.
Yes.
Being past due obligation of patients Daniel Fadi, loan customers.
Yes.
Who do you address that exhibit 6 to?
Yes.
My lord, Ibom Fadama, Microfinance Bank.
To Ibom Fadama
Number Limited.
Micro
Finance Bank Limited.
Yes.
Mr. Robson, The defendant wrote exhibit PDA 6 when Ibom Fadama required from the defendant to give the status report of the claimant. That is correct.
Yes.
My lord, I need to confirm
Please.
the exhibit you just cited.
That is the one you are handling.
Okay, my lord. You are holding the exhibit.
No, sorry, my lord. My lord, he has mentioned that there's a document that was written to the defendant, which made this.
That's not correct.
Beautiful. That's how these lawyers, they are not part of what you are doing here. Leave them. If they are here, they will be jittering more than you. That's how your question.
Yes, Mr. Obot, I didn't hear you well. Yes, what are you trying to ask?
Okay. Yes, my lord.
Yes.
Yes, my lord, I was requesting your lordship with the greatest respect to guide us with the last minute.
The last thing I recorded was exhibit PDA 6 is not a status report, but it's an outstanding balance. Exhibit PDF 6 was addressed to Ibn Padama Microfinance Bank by the defendant.
Thank you. My lord will proceed from there.
You are trying to ask him whether the defendant wrote exhibit PDF 6 when Padama requested, the defendant to do that. I think something like that, yes.
Okay, my lord, I thank you, my lord, I'm well guided.
Yes.
Defendant, Mr. Robson, did Ibn Fadama, to your knowledge, request for the status report of the claimant from the defendant?
Yes, my lord.
Yes. Ibn Fadama. Is it microfinance?
Yes, my lord.
Requested a status report of the claimant?
Of the claimant.
From the defendant.
Yes, my lord.
Yes.
Oh, fine. Now, Mr. Robson, please take a look at this with PDA 6 again. Sorry, I'm very sorry. As at the time you wrote, the defendant wrote exhibit PDA 6, the claimant was working with the Ibn Fadama Microfinance Bank. That is correct.
Yes, my lord.
That at the time that the exhibit is PDA 6 was written,
by the defendant.
Yes.
To
The
Padama.
claimant was working with Padama.
Yes, was working with Padama Microfinance Bank.
Okay. At the
Thank
time that exhibit PDA 6 was written by the defendant to Padama, the claimant was working with Padama. Yes.
Thank you, my Lord, for the patience. Mr. Robson, you have told the court that Ibn Fadama wrote to the defendant and requested for the status report of the claimant. Do you know if the defendant issued the status report of the claimant to Ibn Fadama?
Yes.
I have no idea.
Yes. Eh?
I have no idea, my lord.
Okay, I have no idea whether the defendant issued a status report of the claimant to Padama Microfinance Limited. Yes.
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 Since you say you don't have an idea, let me go along with you. If the defendant did not issue, do you know the reason they did not issue? Tell the court the reason they did not issue. Mr. Robson, the court is waiting for you.
This kind of rephrase the question.
Tell the court the reason the defendant did not issue status report to Ibn Fadama.
I have no idea, my lord.
I don't know why the defendant not issue
Please repeat it. Yes.
the status
This is the one for the
report.
defendant.
Yes.
Please look at exhibit PDA 6 again. You say you have no idea.
Yes.
My Lord, permit the defendant and the witness to refresh himself by reading exhibit PDA 6.
Yes.
Okay. Now, my Lord, you have done so. Witness, the reason that you did not issue, the defendant did not issue status report to Ibn Fadama was the fact that the defendant said the claimant is owing 1,891,191.85. That is correct.
I cannot confirm that, my lord.
Yes, Mr. Obot, I don't understand.
Okay. From exhibit PDA 6,
Yes.
the reason the defendant did not issue status report was because the defendant alleged that the claimant was owing 1,897,190.85.
Okay. Yes, Mr. Witten, is that so?
My lord, I cannot confirm that since the subject of this PDA 6A to C does not relate to
no
people's
idea
inquiry.
whether So he said he doesn't have an idea whether the defendant did not issue the status report because the claimant was owing the defendant 1,897,000 naira. Yes. Yes.
Thank you, my lord, for the question. I didn't know. I'm sorry, my lord. My lord, the next question, sir.
Okay. Yes.
I show exhibit CR3 to Mr. Robson. Mr. Robson, kindly take a look at exhibit CRM3. Yes,
That's
my lord.
The resignation letter.
Yes, ma'am. Since the defendant received exhibit CRM3, did they write any letter to the claimant that they have not accepted her resignation?
Yes.
Letter to the claimant that her resignation letter was not accepted?
I have no idea, my lord.
I have no idea whether defendant has accepted claimant's resignation letter. Yes.
Sorry, my lord, I didn't hear my lord.
Say he doesn't have an idea whether the defendant had accepted the claimant's resignation letter.
No, my lord. Sorry, sir. Whether the defendant has written any letter that they do not accept the claimant's resignation.
Okay, whether they had not accepted.
Whether they have written any letter of non-acceptance.
That is
non-acceptance.
He doesn't know whether the defendant had not accepted the claimant's resignation letter, isn't it?
No, sir.
I have no idea whether the defendant had not accepted, isn't it? Had not accepted.
The defendant has written a letter of non-acceptance.
That is had not accepted now. It's the same thing now. Whether it had not accepted the claimant's resignation letter.
My lord, if my lord puts it the way I will also understand, it will help me, sir. Please, my lord. Whether the defendant has written a letter that they do not accept the claimant's resignation letter. And he said he has no idea. Thank you, my lord.
I have no idea what the defendant had written. Had written a letter.
Has written a letter of non-acceptance. Yes, my lord. My lord, I'm so sorry. The English language is a very big problem. But allow this way, my lord.
Is it even a requirement of the law that the defendant should accept or not somebody's resignation letter? It's not even a requirement of law. Once somebody has resigned, an employer doesn't have any right to say, I'm accepting your resignation, I'm rejecting your resignation. He doesn't have a right to reject or accept, because once somebody has resigned, once you have resigned, then you have left the service of that, employer. The issue of acceptance or rejection of the resignation doesn't even arise. Yes, because you can't impose an employee on an employee. In any case, you can proceed. Yes. I have no idea whether the defendant had written a letter of non-acceptance of the criminal resignation letter. Yes. Yes. You are muted. You are muted. You are muted. I can't hear you. You are muted. Ask them to unmute you. Hey, where is the flag?
Thank you. My Lord can hear me now.
Thank you. Yes, I can hear you now. Yes.
Thank you, my Lord. Mr. Ronson, the resignation procedure from the employee or from the employment of the defendant was expected to be done through the immediate supervisor of the claimant. The claimant was to resign through, to route a resignation letter through her immediate supervisor. That is correct.
No, my lord.
Tell the court who she was to write the resignation letter to.
Yes.
My lord, it can be routed through the admin and finance as well as the managing director.
It can
Through
be
the admin.
Admin and finance department as well as the
Okay.
managing director.
So claimant resignation letter should be routed through the admin
And finance department.
admin and finance department.
Can it also be routed
As well as the managing director.
As well as the MD. Yes.
Can it also
Yes.
be routed through an immediate supervisor to the MD?
Supervisor to the MD or to the claimant?
Managing director.
Supervisor to the.
Can it also be routed through her immediate supervisor to the managing director?
Okay, yes.
I cannot confirm that, my lord.
Cannot confirm.
I cannot confirm whether the resignation letter can be routed through the claimant supervisor to the.
Please give me
Yes.
Please take a look at this resignation letter and tell the court that was received by the defendant who it was routed through. Who did the claimant put the letter through? Look at the exhibit. Exhibit CRN3.
Yes.
Good.
Yes. Yes.
Please take a look at exhibit CRN3 and tell the court who the defendant sent the letter to. The resignation letter that he received on the 21st March 2020.
My lord, the managing director.
Beautiful.
Exhibit CRM3
And 3 was addressed to the managing director of the defendant.
addressed to the MD of the defendant. Yes.
Yes,
Yes.
you've already told the court, you have already told this court that you don't know who was the immediate supervisor of the claimant as at the time she was working there. Are you still maintaining that? Or you now remember who was?
Yes. Yes.
My lord,
Do you now remember, told the court that you did not remember or you did not know who was the immediate supervisor of the claimant. I'm asking you, do you still maintain that, or you now remember who was the boss, the immediate boss of the claimant when she was working with the defendant?
Yes. 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 Hmm?
The immediate supervisor wasn't mentioned. I mean, the MD wasn't mentioned. Instead, he mentioned the immediate supervisor.
Who
Instead
was
of
the
MD.
person?
I mentioned the MD, and I didn't
No,
talk about the immediate supervisor.
No, whether you know the claimant's immediate supervisor. Yes. Yes.
My lord, please, I didn't get that.
Say the claimant's immediate supervisor.
My lord, the managing director.
Okay, the MD, the claimant's immediate supervisor. Hmm? Witness.
Yes.
He's asking you a question and you're giving this way.
I said the MD is the claimant's immediate supervisor.
Yes, my lord.
Okay. The MD is the claimant's immediate. Yes.
Is he dead or alive? Is he dead or still alive?
Yes,
My
yes,
lord
yes.
is dead.
Eh? He's what?
He's dead, my lord.
Very well.
He's alive.
Yeah, Robson.
I didn't get him. Mr.
My
Oba, I
lord.
didn't get.
I'm asking Mr. Robson
Is he dead
whether
or-
that managing director is dead or alive.
And what did he say? I didn't
Now,
get him.
Speak to the hearing of the court, please.
My lord, as at when she was working, the managing director was alive, but currently he's no longer alive.
Okay. Yes, yes.
Thank you, my lord. Mr. Robson, please tell my lord, with all respect and with sense of truth, whether you have before this court the report, any report from the managing director whom you say was immediate supervisor of the claimant, whether you have any report from him that the claimant did not comply with the resignation procedure, whether by letter or memo or committee report.
My lord, I responded to it before.
Please respond again.
You can respond again, yes?
I have no
Yes.
idea, my lord.
You have no idea about what? You have no idea about what?
If there was any letter or correspondence.
Stating what, yes?
What is it?
Stating
Yes.
that standing on
Stating that the claimant did not comply with the resignation procedure.
Okay, I have no idea. Okay, whether there is any letter from the defendant?
Any letter from the claimant supervisor or managing director that the claimant did not comply with resignation?
That is from the defendant. That is from the defendant. That's from the defendant.
Okay.
I have no idea whether there's any letter from the defendant that the claimant had any outstanding. Yes.
The claimant did not comply with the resignation procedure.
Yes, yes. Yes.
My Lord, he has no idea. My Lord, a few more questions I'll be done. Thank you for indulging me. My Lord, I'm showing exhibit CRN5. CRN5 to exhibit CRN5 to the witness. Please take a look at exhibit CRN5. Dated what is that? July 28, 2022. The question is, since the claimant resigned in March 2021 from the defendant's employ, exhibit CRN5 is the first letter from the defendant to the claimant since she left the employ of the defendant. That's the first letter you wrote to her.
Exhibit CRN5.
Yes, is the first letter the defendant wrote to the claimant since the claimant resigned from the defendant in March 2021.
Yes. Yes, yes.
My Lord, I cannot confirm if this is actually the first letter written.
Okay, I cannot confirm.
Thank you.
Whether exhibit CRN5 is the first letter written by the defendant to the claimant after her resignation. Yes.
Do you have one Faith Samuel Ibamu in the defendant's employment? Do you have a staff by name Faith Samuel Ibamu in the employment of the defendant?
I cannot remember, my Lord.
I cannot remember. One, is it somewhat?
One Faith Samuel Ibamu. Faith Samuel Ibamu.
Samuel
Ibamu, I-B-A-N-G-A.
I-B-A.
I-B-A-N. I-B-A-N. G-A.
Okay.
G
Ibanga.
as in
I cannot remember one Samuel Ibanga as the staff of the, isn't it?
The staff of the defendant, yes, my Lord.
Yes, yes.
Yes. As an internal control officer, that you told the court that you work across all the departments of the defendant. Have you made any staff by name Faith Samuel Ibamu?
I cannot recall, my Lord.
Yes.
Thank you.
Yes.
Now, please take a look at the exhibit CRN6, dated 26 July 2017. take a look at exhibit CRN 6, dated 26 July 2017.
Yes, yes, yes.
Are you, my question is, okay, did you receive this letter from Active Point Microfinance? Is the exhibit you tender? You receive it? It's correct, you receive it.
My lord, please, I'm going through the letter.
Okay.
Yes, my lord.
You receive it. Defendant received the letter.
Yes, yes, that he received exhibit 6. Is that right?
It's VCR. Yes, my lord. Now, from July 2017, rather, from July 2017, the claimant was working with the defendant until March 2021, despite your receipt of exhibit CRM 6. That is correct. From July 2026 or 2017, you receive exhibit CRM 6. The claimant was working with you until March 2021 when she resigned. That is correct.
Yes.
Yes, my lord.
Thank you.
Until March 2021, when she resigned. Yes.
Lord, I leave Mr. Robson at time, a very fine friend and a good witness of the court at that point. Thank you, Mr. Robson, for coming to court. Hello, that's all for cross-examination.
That's all for us. Yes, re-examination.
Cross-examination of you.
Mr. Godwin, yes.
Yes, my lord, I have one re-examination.
Okay.
Yes, my lord, the witness was shown a letter of resignation and was asked whether that was the one he mentioned in paragraph 7 as the one that was forged, and the witness said no. So my lord, the question now is the witness whether which letter was actually forged, which was mentioned in that paragraph 7. Because the witness said that the letter that was shown to him, which is the resignation letter that was in our custody, he said that one was not forged. And the question now is which one was the one that was forged by the claimant as stated in paragraph 7 of the statement of claim.
That's if we object to that line of re-examination. We show the document. No, sir. No. My lord,
sorry, Mr. Obot. Sorry, let me address Mr. Sorry. Mr. Godwin.
Yes, my lord.
The claimant stated in his pleadings and his evidence in chief. The letter alleged. No, let me learn. A letter been forged, isn't it? That is pleaded, isn't it? You pleaded that. Eh?
Yes, my lord.
Did you plead that? And you tendered that document.
My lord, we tendered the one that was in our custody, which is the one that was not forged. So I was asking him which one was the letter that was forged, which was mentioned in that paragraph 7.
Okay. The one you tendered was exhibit CRM 2. Okay, CRM 3.
Yes, my lord.
That is the resignation letter, isn't it?
Yes, my lord.
Then the one tendered by the claimant
Yes, my lord.
Is
Is the
exhibit.
one that was stated to the court. I was asking the witness to now clarify to the court which one
No, okay,
was.
okay. So let me get to the one tendered by the claimant.
Yes, my lord.
Okay, the one tendered by the claimant is exhibit PDA2, which is the same resignation letter.
Yes, my lord, the same resignation letter, but without the acknowledgement stamp of the.
Okay. And then why are you objecting to that, Mr. You can sit down, Mr. Obot. Mr. Godwin. You can sit down, Mr. Obot.
Yes,
why? No, I mean, Mr. Obot. Why are you objecting to that? You have made mention of a forged document, which he denied it, and he's now trying to clarify that the one that he's referring as a forged one is the one tendered by you, not the one acknowledged. Yes.
Thank you, my lord. My lord, the question. It's not that one. So when we get to the address and the evidence before the court, we will know
No, please, Mr. Obot, you have raised the issue of the forgery, isn't it? The witness said it's not the one that you showed him. So let him, be asked that question so that the court wouldn't be in any confusion.
My lord, with the greatest respect, respect, my lord. My lord, the witness cannot be examined again in chief after my examination.
No, he can do it. He can. I will allow it. Okay. I will allow the question, Mr. Albert, please. I will allow the question.
Thank you, my lord. Thank you.
Yes, so I will make progress, please. Yes, Mr. Godwin. Mr. Godwin.
My lord.
Yes.
Yes, my lord.
So, what is your question, please, on the first document?
My question was that he had told the court that document that was shown to him, CRM3, is not the one he mentioned in paragraph 7 as the one that was forged. Now, the question was, which one was the forged resignation letter?
Under re-examination?
It can be done, please, so that we make progress, Mr. I can even ask it on my own. I can even ask it on my own. Yes.
As the court pleases,
Yes, Mr. Witness. Yes.
My lord, the resignation letter presented by the claimant actually have.
That is exhibit 2. That is exhibit. I think it's exhibit 2. Yes. It has what? What does it have?
Please, I wish to see the one presented by the claimant, the first one.
Please show him the list in the document, please. That's exhibit PDA2. PDA2, yes.
Yes, my lord. From the letter here, the address is inconsistent with that we actually received. And then the tune of the letter is actually also inconsistent. The word usage is not the same as that in the one we actually acknowledge and receive.
So is that the one that was forged by the claimant?
Yes, my lord.
My lord, that's all for the witness.
So exhibit PDA2 is inconsistent with exhibit CRM3 that we received because it is forged by the claimant, according to you, isn't it?
Yes, my lord.
Is that so?
Yes, my lord.
CRM3. Yes, Mr. Godwin, is that all?
Yes, my lord, that's all for the witness. That's all for the witness.
So what do you do, Mr.
My lord, that is the
That's the case for the
my
for
lord.
the
I'd like to take it. We want to subpoena a witness from.
okay.
We will apply to subpoena a witness from the defendant's last place of work.
Okay, and that's okay. That's all for
the witness. This particular person.
And we
Yes,
ask for another date for continuation of defense, isn't it?
my lord. My lord.
For continuation of defense to enable you to subpoena a witness, ba?
Yes, my lord. Yes, my lord.
So which date, Mr. Kon?
My lord, 29th of April.
That 29. Don't put so many cases for Mr. Kon.
My lord, we don't have more.
Okay.
Which page?
Respectfully, my lord, may we return on the 4th day of May 2026 for continuation.
Okay, Mr. Obor, is that okay?
Yes, my lord.
So DW1 is discharged. Meanwhile, case is adjourned to the 4th of May 2026 for continuation of defense. Mr. Okon, is there any other?
Lord. Yes, my lord. Number 2.
Have they?
Number 2. My lord, Ben Dede is being. Barrister Ben Dede is online.
It's online. What about the other ones?
Council. Lord, I can see phone.
Okay. Is in the matter?
No, not that one. Phone.
Okay, call the case so that we'll quickly call the case.
Suit number NICN UY 49 2022 between Anetie Etomasuko and Prudential Gas Limited, Umana J. Umana. Both parties are absent in court.
Yes. 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 Yes, Mr. Ben. Yes. Yes, Mr. Yes. You are muted. I can't hear you.
Oh, I'm sorry, my lord. Ben Dede, my lord.
Yes.
With me and my learned friends, Clement Iziogo. Iziogo is spelled Iziogo.
Okay, yes.
Ifon. And Emmanuel Williams. Ifon, IFON, my lord.
Okay, IFON. Ifon.
Yes, my lord. Yes, my lord.
Ifon Emmanuel.
And Emmanuel Williams.
No, Ifon who?
Ifon.
Okay.
Ifon is one name. She's female.
Okay. Okay, and Emmanuel.
Ifon.
And Emmanuel
Williams. Williams with S, my lord.
Okay, Williams for the
Yes, my lord.
claimant.
Yes, my lord.
Yes, what about the counsel for the defense?
My lord, the defendant's counsel is usually, well, he said he tried to join since morning, and I told him that the lawyer that used to represent him in Uyo was around and online, in fact. Agogo Cletus. My lord, in any case, since he has filed final written address, that can be adopted.
Mr. Agogo Cletus is coming from where?
Agogo Clement, yes, my lord. Yes, he used to apply. He used to appear for the defendants and has filed his final written address.
Yes, I'm saying that he's coming from where? He's coming from within Uyo, or is outside the jurisdiction?
No, my lord, Agogo Clement, Cletus, I beg your pardon, he used to appear, he comes from Calabar.
Okay,
but he has a counsel that used to represent him.
But is he aware of today's date?
My lord is aware he had been trying to sign it since morning. That is usually represented by another counsel here in Uyo.
No, who is trying to
his final written address?
Who was trying to join the Zoom proceeding? See Mr. Agogo or the person that has been representing him?
My lord, Agogo himself called me. Said he had been trying to sign it. That was over 3 hours ago.
Okay.
And my lord, we were at the Federal High Court at the time.
Yes. Yes.
Yes, my lord. My lord, the court had ordered that parties file their final written address. That was as of 19th May 2025, when Samuel Willie appeared for Agogo Cletus.
Yes.
Yes, my lord. My lord, parties have complied fully.
Yes.
The matter was adjourned to 10/2025 for adoption.
Yes.
And finally to today.
Yes, so
Yes,
claimant final written address
my lord,
is
with the court's kind permission. Yes.
Claimant final written address is
My lord,
filed.
defendants filed their final written address. Defendant's final written address was filed on the 15th of May 2025. And the claimant filed theirs on the 19th of May 2025.
Claimant filed on 15th or what?
Defendant filed on the 15th of May. Claimant filed on the 19th.
Of what?
May 2025. Defendant filed on 15/5/2025. Claimant filed on 19/5/2025.
That's after 4 days.
Yes, my lord, 4 days interval.
Okay, yes.
Yes, my lord. My lord, we are ready to adopt the final written address subject to the court's convenience.
Yes, go ahead, yes.
Yes, my lord, upon filing the final written address pursuant to Order 45 of the National Industrial Court Civil Procedure Rules 2017, we have laid out a number of issues. We've introduced the case. We've raised 3 issues which we here adopt to save the time of this honorable court.
Yes.
And my lord, our conclusion with respect is that the claimant has proved his case.
Okay. Yes.
My lord, we therefore submit that the claimant's narrative stands as credible, uncontroverted, and legally established on a balance of probabilities.
Yes.
My lord, in the issue of damages, our position is that
Just adopt. I'll look at it.
yes, my lord, we adopt and pray this honorable court to so hold and give judgment to the claimant in the interest of justice.
Okay, thank you.
Thank you, my lord.
Yes, Mr. Okon.
Yes, my lord.
Today is 27th, 25th.
25th.
Yes.
Yes.
April, May, June. Which date?
Lord, 15th of June.
Okay. 15th of June.
Yes, my lord.
Is that okay, Mr. Ndedi?
My lord, 15 June is convenient. Yes, my lord.
Okay, so case is adjourned to the 15th of June 2026 for judgment. Here notice shall be issued and served on the defendant.
As the court pleases.
As court is
So,
thank you, my lord.
ladies and gentlemen, Mr. Obot, Mr.
Yes,
Godwin,
my lord.
and your powerful team.
Thank you, my lord.
That will be all for today. I'm wishing you good afternoon. I'm wishing you good afternoon. Thank you so
Thank you,
much.
my lord.
Thank you for
My lord, we waited here.
Thank you, my lord. We are grateful.
Yes.
We waited to have your lordship so that we share the Ramadan celebration. We didn't see your lordship.
Okay, if you can accept Ramadan, this thing, is it acceptable?
Mr. Dede likes it very much. Thank you, sir. Until when my lord returns.
As long as it comes from my lord, we're okay.
No, I can send you e-kilishi, e-meat.
E-kilishi, my lord, we'll receive it, my lord. It will be an honor.
Okay. What you just do is send your email address. Just send me your email address. There I will send the kilishi and the other things, goodies.
Yes, my lord. Thank you, my lord.
Thank you so much.
Nice
Thank you. Thank you so much. Good afternoon. Rise. Thank you. Okay.
God.
Yes, I am.
Yes, yes, sir.
Fortunately, in case you were in, I didn't want to let it crash on you.